I kindly request our President of Advocates Association of Western India, Prashant Revekar sir, to kindly give welcome speech.
Good evening, Honorable Justice Marne, esteemed members of the bar. On behalf of AWI, I would like to welcome you all for today's lecture. We are honored to have with us a distinguished judge, Honorable Justice Marne, to address us on the topic of Maharashtra Rent Control Act 1999. Today we are incredibly fortunate to have him and share his Lordship thoughts and insights on this topic. His Lordship perspective is invaluable, and we eagerly look forward to learning his vast experience. Without any further delay, I would like to welcome his Lordship, give him a warm welcome. Further, I'd like to add, he's a very good photographer. His Lordship is a very good photographer.
I kindly request Shri Ram Kulkarni sir, President of Adhivakta Parishad, to give a brief introduction of Adhivakta Parishad and the lecture series that has been going on since a very long time uninterrupted.
My Lord Honorable Justice Marne, President Mr. Redekar, committee members, distinguished members, senior members and all my colleagues. I am here to introduce what is Adhivakta Parishad. Adhivakta Parishad is basically introduced by Mr. Dattopant Thengdeji. In 1992 it was founded by him, and his basically is working, as you can see the motto, Nyaya Mama Dharmaha, means we are all, organization is working and for the justice which is religion for us, and we believe in that, and maximum members of us are working for that. We are working for promoting the rule of law, working for our fraternity, and across the country we are discharging various functions or organizing the programs toward the society. We owe responsibility toward the society. This is basically a social organization, and this is also for promoting our fraternity. It is from that point of view it is founded, and we are also trying to reach many of our members to join this organization, and as a part of this we are organizing this lecture series, Adhivakta Parishad, so that we can have, till date we have 27 lectures delivered by the distinguished judges of this court, senior advocates, and now we will, all of us are eagerly waiting for you. So with this, now I will request the Mr. to take over.
I proceed to introduce today's subject as well as introduce our honorable speaker. Introducing our speaker, Honorable Justice Marne sir. Justice Marne completed his 5 years law course from ILS Law College, Pune, post-graduation from Pune University, enrolled as an advocate with Bar Council of Maharashtra in Goa in 1996. Initially practiced over 8 years in Pune District Court and shifted to Mumbai in 1997. Practiced extensively in appellate and original site jurisdiction of High Court. His areas of practice included municipal and town planning laws, service laws, copyright, arbitration, civil, commercial and constitutional matters. Represented several municipal corporations like Navi Mumbai, Nashik, Pimpri, Chinchwad, as well as statutory bodies like Slum Redevelopment Authority, Shipping Corporation of India, MTNL, Pawan Hans, handled litigation of Copyright Society for lyric writers and music composers relating to licensing of Indian and foreign works. As our Honorable President rightly said, he has keen interest in wildlife photography. He has been elevated as Additional Judge of Bombay High Court on 19 July 2022. I request our Honorable President of Advocates Association of Western India to kindly felicitate him. I kindly request our Honorable Speaker to kindly enlighten us on today's topic.
Mr. Redekar, the Honorable President of Advocates Association of Western India, Mr. Sabrad, the Honorary Secretary of AVI, all the committee members of Advocates Association of Western India, Mr. Sriram Kulkarni, the President of the Adhivakta Parishad, all the members of the bar. Very good evening to one and all, and thank you for inviting me for today's lecture series, and thank you very much for remaining present in such a large number. Honestly, I never expected so many persons will come, but I am really thankful that all of you think that I can give you some insight on a area of law which I had really not practiced, and as I go ahead through my lecture, you'll possibly notice that as well. But speaking about this bar room, this gives me actually a great sense of pride to be here and be amongst you and deliver a lecture as a part of V.T. Valavalkar lecture series. Coming from Pune back in 1996-1997, as many of you might know that I was not a regular visitor to any of the Bar Association rooms either. I've been a member of AAWI and Bombay Bar Association for a long time, but I used to operate mostly from offices and rarely used to visit or sit in any bar room as such. I never had any table. My senior also practiced back in those days in CAT. So whenever I used to sit in bar room for some time, it used to be in CAT bar room. So those days, sometimes I used to enter room number 18 to have a cup of tea. And I always somehow carried a feeling that I don't belong to here, and all the tables are owned by the seniors and their juniors. And I'll be driven out of the bar room. Suppose with great sense of apprehension, actually, I used to, occupy a chair those days. So, considering the timid and say shy personality like me, who didn't have that much of confidence to even enter a bar room, today to stand amongst you and deliver a lecture to all of you actually is a long journey for me. And thank you very much for inviting me for today's lecture series. I must say one more thing. Sometime, I think in 2015, your secretary, Mr. Sabrad, purchased my office. And that time, he told me that because 18 I used to go sometime, but 36 I barely entered. So he said that you can come at any time at this table for having cup of tea. So maybe after 2015-16, I was seen a little bit sitting there in that table having cup of tea sometimes. But I never thought in my life that I will get this opportunity to deliver lecture in this majestic bar room. So thank you once again for inviting me today. When the committee approached me for delivering this lecture, the initial feeling is that because I am not a very good public speaker, so I can't speak impromptu, I need to prepare. And time, as you all know, is a constraint for all the judges. And the initial reaction was no. But then I thought that where am I going to get this opportunity to enter this bar room and deliver a lecture? So I said yes. Then they said topic. Since they knew that I used to practice I used to represent municipal corporations, had delivered some lectures on town planning. And so they said, please deliver lecture on MRTP Act, because so far nobody has delivered that lecture. And I also said yes. As a couple of days passed and I was just scrolling through my old lectures, then I realized that it's been a long break that I have not been sitting in division bench, and most of these MRTP matters go before division bench. So I've lost touch. And suddenly, in a spur of a moment, I thought that why not try something new? Why not speak about something that I've never really practiced? Honestly, in my entire career, I may not have done even 10 rent act cases. So I said, let us try something. And this is an impulsive decision. And I suddenly told one of your committee members that let me try my hand at the rent act. This is how I am taking a chance today before all of you to deliver a lecture on a rent act. For juniors, I don't know, it might be somewhat useful, but for seniors, it's question mark. I don't know why all of them have come here. I never expected them. पण कधी कधी काय असतं की आपल्याला माहिती असलेली गोष्ट एखादा छोटा मुलगा जेव्हा अडखळत चुकत सांगतो ती ऐकायला पण मजा येते. त्याप्रमाणे होपफुली त्यांना माझं लेक्चर ऐकायला मजा येईल, कारण मी जे सांगतो ते पॉसिबली त्यांना सगळ्यांना माहिती आहे. अनलेस ते माझ्या चुका काढायला इथे आले असते तर मला माहिती नाही. पण आय रिअली नेव्हर एक्सपेक्टेड द सिनियर्स टू कम अँड अटेंड माय लेक्चर. सो हिअर वी बिगिन द लेक्चर ऑन द रेंट ऍक्ट. Lex injusta non est lex. An unjust law is not a law at all, was the contention of landlords before the Supreme Court while mounting a challenge to the provisions relating to fixation of standard rent under the Bombay Rent Act 1947 in Malpe Vishwanath Acharya. Rent control across the globe is a government policy and a program essentially aimed at ensuring affordable housing for lower income residents in urban areas where cost of housing was escalating. While one of the objectives which all of us know is to provide for protection from rent escalation and eviction, the other important objective behind rent control legislations, which is often lost sight of, is making available the rental housing stock in urban areas where residents find purchase of properties increasingly difficult. This particular objective is often ignored, which I think is one of the main objectives behind rent control legislations across the globe. You can see, so what happens is that all of us usually feel is that rent control legislation, Rent Act is essentially meant for protection of a tenant. But if you think from a different perspective, why rent control is necessary? Basically to govern the relationship between a landlord and tenant, to formalize that arrangement, a house owner giving his house to a house user. So you need to provide some sort of an assurance, some sort of a guarantee to that house owner that he will get back his house. He'll get back the return on his property in the form of rent. So the main objective is to give that sense of assurance to the house owner so that then he becomes ready to let his house being used by a tenant. So this was the main idea in those times when various countries across the globe thought of bringing in the rent control legislation. Maybe it has not definitely served this objective that I am talking of, and we'll consider it why. But if you turn to say today's situation, today this live and license agreement, many of you might be either owning the houses and some of you might be even living on a license basis. But today the arrangement that the legislation provides gives a sense of assurance to the house owners that if I give my house on live and license basis, number one, I will get my license fees every month, and number two, at the end of the license period, I will get back my house. Barring few aberrations where the licenses do not vacate or do not pay, for which there is a summary remedy under section 24 which we will cover during the course of the lecture. But this sense of assurance which the today house owners get that they will get back their possession and receive the license fees agreed between the parties is something that encourage the house owner to give his premises on license basis, which is the reason why in a metropolitan city like Mumbai, about 30 to 30% houses today are being occupied on tenants, in the sense license basis, which also ensures, so this is a win-win situation for both. Person who's in need of house also gets a house for being used, and the landlord who has excess money, who can invest in rental properties, also gets return on his. So to the extent of live and license basis, I would say, and I hope all of you will agree, that this legislative governance of the arrangement has ensured availability of housing stock in the urban countries, which was the original objective when the rent control legislations were initially brought in across the globe. What happened in India is slightly different. After we got independence, the economic landscape was such that very few citizens had means to purchase homes. The money power was in the hands of few who owned lands and could bear the expenditure for construction of chawls, buildings in urban areas. Various states therefore enacted their own rent control legislations, primarily aimed at controlling the rent escalation and also dealing with the protection from eviction. The state of Maharashtra, which had and still continues to have possibly the highest percentage of urban population, enacted the Bombay Rent Act in 1947, which received governor's assent in 1948. The act was a temporary measure and was to apply only for 2 years. It, however, got endlessly extended and operated for next 52 long years until its journey was finally halted on account of the Supreme Court judgment in Malpe Vishwanath Acharya, which judgment we will consider a bit later. Though the Bombay Rent Act came into effect in 1948, it somehow fixed the date of 1st September 1940 as a reference date for fixation of standard rent provisions. Section 510 of the Bombay Rent Act defined the term standard rent, amongst other definitions, by drawing a timeline with reference to the date of 1st September 1940. It provided that if the premises are let on 1st September 1940, the rent at which they are let becomes the standard rent. If the premises are let before 1st September 1940, the rent at which they are last rent for let, for example, they are let in 1920 for rupees rent of say 25, but by 1938 the rent has increased to say rupees 40. Rupees 40 becomes the standard rent. And it also says that if the premises are let after 1st September 1940, the rent at which they are contractually lent becomes the first let, becomes the standard rent. So suppose the tenancy is created in 1960, say at a rent of 500 rupees, 500 rupees becomes a standard rent. Thus the rent at which the premises were first let after 1st September 1940 became the standard rent. As I said, to illustrate, if the premises are let for a rent of rupees 100 on 1st January 1950, the same became the standard rent, which was impermissible to be increased, and Section 7 rendered demand in excess of standard rent and permitted increases illegal. Thus, once the landlord agreed to demise the premises at a particular rent, the contractual rent became the standard rent forever, and the landlord could only demand the permitted increases as provided within the statutory framework. The notable feature is that despite virtual freeze of the standard rent, the landlord still went on creating tenancies in India. I don't know why, but possibly on account of either lack of demand for housing for outright purchases or absence of capacity for home seekers to bear the financial burden of purchase of house. So what landlords in many cases did was to accept a sort of a premium or pagadi for creation of tenancies. This is how the arrangement of creation of tenancies continued for a long time, and the landlords either took the risk or had no alternative but to create tenancies in absence of demand for outright purchase. In cities like Mumbai, Pune, etc., at one point of time, there were more tenancies than outright purchases of homes. This possibly prompted the legislature to extend the validity of Bombay Rent Act from time to time. Just to make little humor, what we can say is that त्यावेळेला कदाचित मला असं वाटतं की असं का झालं, जेव्हा सगळ्यांना कळलं की 1940 नंतर जो रेंट फिक्स होईल तोच स्टँडर्ड रेंट असेल, तरी लँडलॉर्ड्सनी का टेनन्सीज क्रिएट केल्या. वन एक्झाम्पल ऑफकोर्स, वन रिझन ऑफकोर्स इज बिकॉज देयर वॉज नो डिमांड फॉर परचेसेस. मे बी कदाचित असं असेल की लँडलॉर्ड्सला स्वतः टेनंट्सवरती स्वतःची हुकूमत गाजवायची असेल, त्याच्यामुळे कदाचित हे करायचं असेल. पण जसा वेळ बदलत गेला आणि वेळ पुढे गेला, हळूहळू टेनंट्स लँडलॉर्डवरती कुरघडी करायला लागले आणि स्वतःचं श्रेष्ठत्व कसं काय प्रूव्ह करायचं, लँडलॉर्डपेक्षा आपणच कसे मोठे आहोत, पर्टिक्युलरली काही शहरं पुणे वगैरे अशी, त्याच्यामध्ये जरा जास्त कदाचित आलं आणि मग पुढे हळूहळू त्याचे प्रॉब्लेम्स तयार झाले. सो ॲज टाइम प्रोग्रेस्ड, द लँडलॉर्ड स्टार्टेड फीलिंग द हीट as the property prices started soaring and the return on investment in the form of rent became negligible. Far from earning any profits on ownership of buildings, the old buildings became liability for them to maintain, where the tenants were enjoying occupancy by virtually paying peanuts. The landlords therefore started shying away from creating new tenancies, and availability of rental housing stock in urban areas started declining. A general perception was formed that rent control legislation was only for protection of tenants, and the other important objective of making affordable rental housing stock was increasingly kept on the back seat. It is only in 1987 that the latter objective of need for releasing some more housing stock in the market was felt by the government, and steps became necessary to relax the rent control and freezing of the standard rent. An important amendment was brought in by Amending Act of 1987, by which subsection 1 capital A was inserted in section 4, by which it was provided that provisions relating to standard rent and permitted increases shall not apply to premises let in buildings constructed or reconstructed after the date specified by the state government. The state government specified the date as 1st October 1987. So in 1987, the amendment provided that any building which is constructed after 1987, the standard rent fixation will not apply for a period of 5 years. Thus, for encouraging the landlord of new buildings constructed after 1st October 1987 to create new tenancies and thereby bring in additional housing stock in overcrowded cities like Mumbai, Pune, Nashik, such tenancies were freed up from standard rent fixation for a period of 5 years. In the definition of the term standard rent under section 510, it was also provided that after expiry of period of 5 years, the landlords were permitted to charge rent equivalent to 15% return on investment in land and construction in respect of such new buildings. However, this relaxation in the standard rent fixation was made only in respect of buildings constructed or reconstructed after 1st October 1987, and the grievance of landlords in respect of buildings constructed prior to 1987 still persisted. It is this grievance of the landlord which gave birth to the historical judgment of the Apex Court in Malpe Vishwanath Acharya, which in my view marks a watershed moment in the alteration of direction of rent control legislation in the state of Maharashtra. 2 writ petitions were filed in this court in 1986 and 1990, challenging the constitutional virus of section 510, 11 and 12 of the Bombay Rent Act relating to the standard rent fixation by landlords. By judgment of 19 December 1997, the division bench of this court dismissed the petitions. The landlords challenged the judgment of the division bench before the Apex Court in Malpe Vishwanath Acharya, and their submission, as I started in the beginning, that no law which is unjust is law at all. This is how they sought to describe the Bombay Rent Act at that point of time before the Supreme Court. The Apex Court considered the financial impact of rent restriction provisions. It took into consideration, by way of illustration, the percentage of salary being earned by an assistant in the government of India, and found that he was spending 20% of his wages on rent in 1950 or 1960, whereas by 1997, the burden of rent on him was only 0.9%. This is how the Apex Court felt that the rent control legislation was proving to be a windfall gain for tenants at the cost of landlords. The Apex Court took into consideration 1987 amendment, but was not convinced that the same offered any solace to the majority of landlords. The Apex Court therefore came down very heavily on the provisions of the standard rent fixation in Bombay Rent Act, and was on the verge of declaring the same to be arbitrary and to strike it down. However, at the last moment when the judgment was being pronounced, the state Maharashtra state government represented before the Apex Court, that is what it was in the process of bringing in new Rent Act, because Bombay Rent Act, as I said, was only initially meant for a period of 2 years and was being extended in 1997 when Supreme Court was delivering the judgment. So the state government assured the Supreme Court that we'll bring in the new Rent Act and will address all the concerns that are being expressed by the Apex Court. This is how the Supreme Court judgment in Malpe Vishwanath Acharya finally brought an end to the extensions granted to the Bombay Rent Act, and the state government was forced to bring in the new act. Now, even during that gap, a lot of events took place which are very interesting to note. As a matter of fact, the state government had actually started taking steps to bringing the new act, and in 1993 a bill was introduced in the houses of State Assembly on 27th July 1993. The council adopted a motion for reference of the bill to a joint committee of both the houses. By the time the Apex Court delivered judgment in Malpe Vishwanath Acharya on 19th 1997, the joint committee had taken several heavy hearings between 93 to 1997, but had not made any report or any recommendations as such. The new Rent Act proposed in the LC Bill 6 of 1993 contained pari-materia provisions about standard rent fixation, except changing the reference date from 1st September 1940 to 1st October 1987, which is that newly constructed building. It provided for standard rent fixation of premises let on, before and after 1st October 1987. The bill proposed a 40-year holiday for standard rent fixation of premises constructed on or after 1st October 1987, with further provision for fixation of standard rent in respect of such premises at 15% return on investment in land and construction after a period of 40 years beginning from 1987. The judgment in Malpe Vishwanath Acharya changed the scene completely, and a virtual threat given by the Apex Court in para 32 of the judgment that any further extension to the Bombay Rent Act without bringing it on par with the views expressed in the judgment would be declared arbitrary. The joint committee finally took note of the judgment of the Apex Court, and then the further hearings took place in the light of the observations that the Apex Court made. After a lot of deliberations with the stakeholders, the Maharashtra Rent Control Act 1999 was ultimately enacted, which came into effect from 31st March 2000 after taking into consideration the inputs that the joint committee gave. The MRC Act has attempted to strike a balance between interests of landlord and tenants. It doled out what the Apex Court has termed in its judgment in Leelabai Gajanan Pansare, a economic package. The Apex Court in para 59 of the judgment in Leelabai Gajanan Pansare has described MRC Act as a sequel to its judgment in Malpe Vishwanath Acharya. Three striking elements of this economic package, as noted by the Apex Court in Leelabai Gajanan Pansare, are: 1. Exclusion of cash-rich entities under Section 31B. So banks, PSUs, statutory corporations, foreign missions, international companies, most importantly public and private limited companies having paid up share capital of 1 crore or more, all of them are now excluded from the purview of Maharashtra Rent Control Act, which the Supreme Court described as cash-rich entity. So anybody who is able to afford rent was excluded. So affordability of rent became a principle for the purpose of denying them the provision of rent control and standard rate fixation. Second part of the economic package was permission for the landlords to charge premium under Section 56. So now it has become lawful for the landlords and for the tenant also to accept premium. So today a tenancy can be created, the landlord can lawfully accept the pagdi, even the tenant can transfer his tenancy to a third party by accepting premium. The third important factor is annual increase in rent at the rate of 4% under Section 11. I believe the constitutional validity of this particular provision is under challenge before a 9-judge bench of the Supreme Court in Mumbai Property Owners Association, and I believe it's been pending for a long time, 2005 I guess, and I hope in a few days the judgment should come out. So in Leelabai Gajanan Pan, so what can be done now is, after coming into effect of the Maharashtra Rent Control Act, every year the landlords are permitted to increase the rent by 4%. So in Leelabai Gajanan Pansare, the Apex Court was considering the issue as to whether government companies are covered by the term public sector undertaking in section 31B of the MRC Act, and the issue was answered in the affirmative. And in the context of answering that issue, the Supreme Court branded the MRC Act as an economic package because it sought to take out the control of rent control provisions of cash-rich entities. Now, since we are on the topic of section 31B, which is an exclusion provision, a quick reference I think is necessary to the controversy as to whether a cooperative society is covered by the word corporation, which is used under section 31B of the Maharashtra Rent Control Act. In Daman Singh versus State of Punjab, in a completely unrelated scenario, and usually I know Daman Singh for a different principle altogether. So whenever you don't argue something before the court, you can't file review. So Supreme Court says that if the point is argued and not decided, you must file a review, go back to the court, that's the principle which usually Daman Singh is used at. But in Daman Singh, the other issue before the Supreme Court was whether a cooperative society can be considered as a corporation for the purpose of applying Article 31 Capital 1C for repelling challenge to amalgamation of cooperative society. While answering the issue, the Constitution Bench considered the question whether a cooperative society can be treated as a corporation in a generic sense and answered the question in the affirmative. So everybody started feeling that every cooperative society becomes a corporation and therefore it will get excluded under section 31B. The judgment in Daman Singh was often quoted. I have delivered a judgment in Shetkari Sahakari Sangha Limited, Kolhapur, and I have held that a cooperative society is not a corporation established by or under control of a central or state act. And the generic description by the apex court in Daman Singh that a society is a corporation does not make every society a corporation established by or under an act of central or state, and therefore it will not get excluded from the protection of Maharashtra Rent Control Act. So the reason for taking you through the history behind the enactment of MRC Act was for understanding the paradigm shift in the approach of the legislature toward landlord-tenant relationship. The changing demographics and economic landscape of the country appears to have been taken note of by the legislature for striking a balance between interests of landlords and tenants. To borrow the words of Justice Kripal in Malpe Vishwanath Acharya, the tenants were getting unwarranted benefit or windfall on account of freezing of standard rent fixation provisions. While as lawyers and judges, we mainly concentrate on the aspect of eviction. But if we do a little deeper thinking, the root cause behind the unsavory relationship between landlord and tenant is actually the standard rent. Landlords contend that provisions for fixing of standard rent has completely done away the factor of affordability of rent, and rent has become so ridiculously low that it is not unaffordable to any tenant. Therefore, no tenant gives up tenancy and vacates the premises because he or she cannot afford to pay the rent. The tenants have their own version for not hiking the rent. Since the issue of constitutional validity of standard rent fixation provisions under MRC Act is pending before the apex court, it would be premature to make any comment on that debate as of now. An interesting issue while we are on standard rent, an interesting issue was raised before this court, possibly for the first time, that a standard rent cannot be fixed in respect of tenancies created after 1st October 1987, and that fixation of rent for such tenancies must be left to the market forces, meaning thereby that landlord is free to demand market rent in respect of tenancies created post 1987. In a very recent judgment in Britannia Industries versus Maya Alag, I had an occasion to resolve this rather intricate issue. As I said earlier, the date of 1st October 1987, which is a reference date for fixation of standard rent under section 714B of the MRC Act, essentially came from 1947 amendment to the Bombay Rent Act, where standard rent fixation was relaxed for 5 years in respect of buildings constructed after 1st October 1987. While the bill for the new Rent Act was drafted, that period of 5 years was proposed to be extended to 40 years from 1987, and therefore the date of 1st October 1947 was proposed to be continued in the new Rent Act as well. However, after a slap on the wrist by the apex court in Malpe Vishwanath Acharya, the Joint Committee thought that freezing of standard rent needs to be done away with and recommended deletion of clause 3 from section 714B, which had proposed fixation of standard rent in respect of tenancy provision completely. So the Joint Committee recommended that after 1987, let us delete, because it was under threat of the Supreme Court. So let us delete the standard rent fixation completely. Thus a sort of confusion got created into the concepts of construction of building of 1987 and creation of tenancies of 1987 while adopting that particular date. Therefore, you will not find any provision as to how standard rent needs to be fixed in respect of post-1987 tenancies. As I said, Bombay Rent Act said 1st September 1940, tenancies created on, before and after. Now, interestingly, in the Maharashtra Rent Control Act, there is a provision for fixation of standard rent only in respect of tenancies created on and before. After is deleted. So, if any tenancy is created after 1st October 1987, there is no statutory guidance in the Rent Act as to how the standard rent of that premises will be fixed. Now, this particular deletion of the clause, read with a specific recommendation by the Joint Committee that let us do away with standard rent fixation completely for post-1987 tenancies, albeit bit much later, I think almost after 24 years. But this particular issue got raised that please read it, nobody is reading it. This after 1987, now there is no provision only for fixation of standard rent. How courts are entertaining applications for fixation of standard rent. And therefore, in that case of Britannia, this particular aspect was argued before me. Though the issue of court's power to fix standard rent of post-1987 tenancies is resolved, So what I struck a balance in that judgment is that because the Maharashtra Rent Control Act has not deleted the post-1987 tenancies from the protection. It has also said that the standard rate fixation will apply to all tenancy. So I have struck a balance that though there is no statutory guidance for fixation of standard rent of post-97 tenancies, it does not mean that the courts cannot fix it. So in that particular case, again there was a slightly more complicated issue of gap period between 87 and 2000 when the MRC Act came, and therefore I held that for the respect of that gap period, the standard rent could be as per the Bombay Rent Act, because the MRC Act had not even come into force before 2000. But now again, in some appropriate case, this issue will come up that if the tenancy is created after 2000, what is to be done? Whether, because there is no statutory guidance, a landlord may contend that you fix market rent, like say following Atmaram principle, get valuation report and fix. But there are problems, and I realize there are problems. For example, if you just walk around in Fort area, today also there are, I think, 70-80% tenanted premises. Lawyers do virtually purchase those tenancies by paying 70% of premiums. So suppose a view is taken that in respect of those tenancies created after MRC Act, market rent can be charged, then what happens to that 70%? But maybe in an appropriate case, the court will have to ultimately decide this particular issue. Having meandered a little bit on standard rent fixation aspect, I think it is now time to discuss what is encountered by most of the lawyers here, which is the aspect of eviction of tenants. The main protection for eviction of tenants is to be found under section 12 of the old Act and section 15 of the MRC Act, which protects tenants from eviction so long as 1. They pay or ready to pay and willing to pay the standard rent and permitted increases, and 2. Observe and perform the other conditions of tenancies. The terms and conditions, however, need to be in conformity with the provisions of the Act. If the tenant commits default in payment of rent, his ejectment is not automatic. The tenant is provided twin opportunities at two distinct stages to make good the default and save the tenancy. As we all know, subsection 2 of section 15 provides that no suit for recovery of possession can be instituted against a tenant on the ground of arrears of rent unless a notice is served on a tenant demanding arrears and period of 90 days expire after service of notice. Thus, a valid service of notice on tenant under section 15(2) is a sine qua non for filing of a suit on the ground of arrears of rent. In absence of proof of valid service of notice, the suit cannot be maintained. There is no dearth of judgments on this aspect, and maybe a quick reference to two judgments of Justice D.G. Karnik in Sitaram Narayan Shinde and Ramasahaya Khatod would be necessary, where the court says that if valid service of notice is not proved, the suit itself is not maintainable. In my own very recent judgment in Gloria Castro, delivered this week, I have held that where there was a mistake in mentioning the correct address, valid service of notice cannot be presumed and the suit becomes non-maintainable. At the same time, as we all know, tenants also create difficulties in the matter of service of notices. You often see the packets coming back with not claimed, left, not found. In a very interesting judgment, old judgment of Madan and Company versus Wazir Zavir Chand of 1989 judgment, the Apex Court has taken note of such situations and has held that all that needs to be done is to simply post the prepaid registered letter at the correct address, and presumption of service can be raised under section 27 of the General Clauses Act. Just to read the words of the Supreme Court, but as against this, if a registered letter addressed to a person at his residential address does not get served in the normal course and is returned, it can only be attributed to the addressee's own conduct. The judgment in Madan and Company has been followed by the division bench of this court in David S. Justice Radhakrishnan judgment, I think David K.N. and of course by me again in Mukesh Kantilal Waghela. So what we have held, what our court has held that once it is tenant's responsibility, suppose he is not using the premises or is gone out, he has to ensure that some arrangement is made to receive the letter. So long as the landlord puts the correct address and sends a registered post AD, that's what the view Supreme Court has taken. It can be a matter of debate as to whether a suit can be maintained on the ground of arrears of rent when the tenant does not actually get to know that he is in arrears. But that's the view taken by the Apex Court, that so far as landlord is concerned, all that he needs to do is to put a correct address on the envelope and post a RPAD letter. Once a notice under section 15(2) is served, tenant gets time of 90 days to make good the default. If he pays to the landlord the entire arrears of rent within a period of 90 days, ordinarily no suit for ejectment on the ground of arrears ought to be filed. So this gives a general perception that if a notice is addressed, notice is met with no suit. Obviously, because the whole purpose of giving notice was to check whether he is giving you rent or not. Once the rent is paid, ordinarily no suit, but we prove our normal perception wrong all the time. So our full bench in Babulal Fakirchanda Agarwal has taken a view that even if the notice is served and the rent is fully paid and there is no arrears, suit can still be filed and the landlord can still check whether he is regularly paying the rent or not under 15(3). So the full bench has taken a view that merely because the notice is made, that doesn't mean that the landlord is prevented from maintaining the suit. Under section 15(3), a tenant who has continued the default even after service of notice gets a second chance to save the decree of eviction by depositing in the court arrears of rent, 15% interest and costs of the suit within 90 days of service of summons. This period of 90 days is held by the Apex Court to be incapable of being extended by discretion of courts. Using the words judicial valor, the Apex Court in Ganpat Ladha has held that discretion cannot be exercised in favor of tenant under the paramateria provisions of section 12(3)(b) of the Bombay Rent Act, and once the statutorily prescribed condition of deposit is not fulfilled, the decree of eviction becomes imminent. The Supreme Court has disapproved the judgment of this court in Kalidas Bhavan, observing, and I quote, Chagla Sise was doing nothing less than legislating in Kalidas Bhavan case in converting the provisions of section 12(3)(b) into a sort of discretionary jurisdiction of the court to relieve tenants from hardships. So the Supreme Court said that you cannot legislate like this. If the legislature provides for eviction on failure to pay within 90 days, the tenancy comes to an end. In Lakshman Bhojraj Khatsne, I have taken a view while sitting at Aurangabad that what needs to be deposited under section 90 is whole rent. So you can't say that I have deposited 90%, 95%. Whole rent, 15% interest and costs of the suit. The other aspect is under section 53, the tenant not only needs to deposit the arrears of rent, but also needs to continue to deposit it throughout the pendency of the proceedings. So the issue often happens that sometimes there is some delay, a month's delay, 15 days delay, 10 days delay. So in Abhay Desai versus KC Chheda, I had an occasion to deal with this issue of mathematical precision in deposit of rent under section 15(3), and it is held that the word regularly used in subsection 3 of section 15 cannot be interpreted to mean that legislature has intended mathematical punctuality in the method of deposit of rent on a particular date for extending the benefit of protection from eviction under section 15(3) of the Rent Act. So long as it is satisfied that the tenant shows reasonable punctuality in the matter of deposit of rent, protection under section 15(3) will have to be necessarily extended to him. I have followed the judgments in Mrunalini Shah, Mohan Lakshman Hede, and of this court in Vasant Mahadev Guzar. Now, coming to the other most important section, which is section 16, under which the eviction on different grounds is sought. Section 16(1)(a) applies when tenant commits any act contrary to the provisions of section 108 small o of the Transfer of Property Act, which in most of the cases relates to commission of act which is destructive or permanently injurious to the premises. To attract a ground under section 16(1)(a), the injury to the premises must be permanent. There is plethora of case law on the point as to which acts of landlords constitute destruction or permanent injury to the premises let, and it ultimately depends on facts and circumstances of each case. Section 16(1)(b) applies when permanent structure is erected on the premises by the tenant in absence of landlord's consent in writing. The issue whether erection of construction outside tenanted premises, because sometimes the tenants contend that the construction has to be on the tenanted premises. I have done something outside. So similar issue was raised before this court in Impex India Limited, wherein it is held that if a tenant carries on construction on a place which he believes to be forming part of the tenanted premises, he would be committing a folly covered by section 16(1)(b) of Rent Act. And the second important aspect is that the section uses the word landlord's consent in writing. So the consent has to be in writing and it cannot be inferred on the basis of a conduct. Then section 16(1)(c) is attracted where tenant's conduct constitutes nuisance or annoyance to the adjoining or neighboring occupier. Now here again there is no limit as to what will cost, what will actually amount to nuisance or annoyance. In the same judgment of Impex India, I had an occasion to examine what will constitute annoyance or nuisance. So I have held that if a plaintiff does not reside on a plot, the first aspect is that the nuisance or annoyance needs to be caused to the neighboring or adjoining occupier, which obviously will include not just occupier, the landlord also. So sometimes it is argued that the landlord is not actually residing there or is not actually occupying a shop next to me. So therefore, even if I commit any nuisance, that will still not attract eviction under section 16(1)(c). In that case, it is held that if plaintiff does not reside on plot adjoining the tenanted premises, he can still be considered as adjoining or neighboring occupier if he owns that adjoining property. Then every act of tenant, this is very important, every act of tenant which interferes with landlord's right to use or occupy his property would amount to actionable nuisance. In our case, in our judgment in Ghulam Hussain Mirza, this court has gone to the extent of holding that every act of tenant which disturbs the reasonable peace of ordinary person and which leads to unpleasurable feeling would constitute nuisance or annoyance. In that case, the act of tenant in constructing a wall in the open land behind tenanted premises, thereby blocking plaintiff's access as well as interference with plaintiff's use and enjoyment of open land, was held to be constituting nuisance and annoyance. In one of my judgments, I have held that the act of tenant taking out morcha and demonstrations in front of landlord's shop would amount to nuisance. Section 16(1)(e) deals with the ground of subletting. Usually, there is no difficulty where the subletting is by a completely third party, and the landlord can prove that the third party is in exclusive possession of the premises, and the subletting can easily be assumed. It is not necessary for the landlord to prove the actual financial transaction between the tenant and the sublettee. Though at one point of time, payment of rent was considered as an essential ingredient of subletting in addition to exclusive possession. And in fact, I have come across one of the judgments of Justice Kingaukar where it is held that unless the payment of rent is, subletting cannot be assumed. But the controversy is now put to rest by the Supreme Court in Prem Prakash versus Santosh Kumar Jain, where, and I will quote these words of the Supreme Court. The Supreme Court says, the landlord is kept out of the scene. When subletting happens, the landlord is kept out of the scene. Rather, the scene is enacted behind the back of the landlord. In such a situation, it would be difficult for the landlord to prove by direct evidence the contract or agreement or understanding between the tenant and the subtenant. It would also be difficult for the landlord to prove by direct evidence that person to whom property had been sublet had paid monetary consideration to the tenant. Payment of rent undoubtedly is an essential element of lease or sublease. It may be paid in cash, in kind, or may have been paid or promised to be paid. It may have been paid in lump sum, in advance, covering the period for which the premises is let out, sublet, or it may have been paid or promised to be paid periodically. Since payment of rent or monetary consideration may have been made secretly, the law does not require such payment to be proved by affirmative evidence, and the court is required to draw its own inference upon facts of the case. The other important facet when it comes to subletting is the concept of family members. When tenancy is sought to be transmitted from one family member to another, sometimes the difficulty crops up. So long as such transmission is from father to son or daughter, or thereafter to a grandson or granddaughter, the heir in possession actually himself becomes a tenant under section 715D, and there is no question of subletting. The difficulty occurs when the distant relatives are allowed to occupy the tenanted premises and the main tenant leaves the premises. Whether such arrangement can be termed as subletting, there are diverse views on this question. Given the joint family oriented concept in India, it is not unusual that the distant relatives are also given shelter in house. Justice Khanvilkar, as a single judge of this court, has held in Vasant Mahadev Pandit that it is not unknown in our society that brothers and wives of the deceased brother would come and stay in case of distress. It is also not unknown that relatives in distress would take shelter in their relations. Therefore, in that case, in Vasant Mahadev Pandit, Justice Khanvilkar rejected inference of subletting when tenant had left the suit premises and had let families of his brothers to use the same. However, the distinguishing factor in that judgment, which I have used in one of my judgments, was that the tenant's mother continued residing in that premises both during and after tenants owns residence. In one of the judgments which, in one of the cases which Mr. Gorwadkar argued, in fact, before me, the tenant had left Mumbai due to his transfer in service and had not returned for several years and was letting the wife of his deceased brother to reside in the premises to his own exclusion. Subletting was proved. The key, according to me, is whether the tenant continues to treat the tenanted premises as his home. Mr. Sabrad was also there. Right? Yes, sorry. The key, according to me, is whether the tenant continues to treat the tenanted premises as his home. If the court finds that the tenant has virtually left the premises lock, stock and barrel and continues to maintain some proof in the form of electricity bill, ration card, and then the subletting will have to be assumed, because if he has no intention of returning, he never returns and just maintains some sort of proof, and then lets generations after generations to transmit the tenancy, I think the court will have to step in. What also needs to be proved usually in case of subletting is exclusive possession. The initial burden to prove exclusive possession by sublettee is on landlord, and once the burden is discharged, it is then for the tenant to rebut the presumption. Again, the test of proof of exclusive possession is preponderance of probability. While dealing with the, and it is generally accepted that for accepting the ground of subletting, one must prove that the sublettee is in exclusive possession. The tenant does not go at all. I have been a little bit adventurous in this area, and recently I have rendered a judgment where I have found that in commercial premises, the situation can be different. And I have given an example of, say, a stationery shop where the shop owner lets another person to install his photocopy machine and independently carry on his business, and both of them occupy the tenanted shop. In my view, this is a clear subletting, because the person is doing his independent business there. He is not an employee. The machine does not belong to him, and the tenant is actually receiving some sort of compensation from him. So though there is no exclusion of landlord in the form of possession, the landlord may retain the key. He may open the door every morning, shut it down every evening. But if the court finds that some other person is also permitted to do business there, and as I just said that in fact proof of payment is not even necessary, then I have taken a view, I don't know how far I am correct, but I have taken a view that in such case, even though there is no exclusive possession with the tenant, the subletting can be presumed. The next and the most popular ground for eviction is the reasonable and bona fide requirement under section 16(1)(g). However, the test of comparative hardship needs to be proved under section 16(2) for seeking eviction on the ground of bona fide requirement. It is by now well settled that landlord is the best judge of his own requirement and tenant cannot dictate the terms on him. At the same time, requirement must be honest and not tainted with any oblique motive, and is not a mere desire or wish. Bona fide need must continue to survive throughout the suit. At the same time, there are judgments which suggest that crucial point is the requirement on the date of institution of suit. Then there are other grounds where the landlord requires the premises for reconstruction of the building. In one of my judgments, I have set aside the eviction decree where the landlord pleaded the case that I need it because I want to pull it down. I have got the plans sanctioned from the corporation, and the suit was filed for simple 16(1)(g) bona fide requirement. So I have said that this is a clear case where you need it for pulling it down, and then I think section 16(6) will apply, where the landlord is under an obligation to put back the tenant in the reconstructed premises of the same size, and there are some other conditions also which the landlord needs to satisfy. So these are the broad or popular grounds on which the evictions is usually sought, although we can go on, but I think there is a time constraint, and I quickly run through a couple of more topics and then maybe we can stop. The other more popular area of litigation now is under section 24 of the MRC Act, which is about the eviction of licensees. Section 24 mandates that a licensee in possession and occupation of premises given on license for residence shall deliver possession to the licensor on expiry of period of license. If licensee fails to do so, landlord is entitled to recover possession from the licensee on expiry of period of license by making an application to the competent authority. The competent authority has to record a satisfaction that the period of license has expired, and once that satisfaction is reached, he can pass an order for eviction of the licensee. Thus, the limited remit of inquiry before the competent authority is about expiry of license. Ordinarily, competent authority is not expected to decide any other question while deciding the application under section 24 of the Act. The marked difference under section 24 is that the summary remedy of seeking eviction of licensee is made available only in respect of license granted for residence. Therefore, if the license is for commercial purposes or for any other purpose than residence, summary remedy for eviction under section 24 cannot be availed, and the licensor in such case are required to adopt remedy for seeking possession of the premises either under section 41 of the Presidency Small Causes Court Act here in Mumbai, or under section 26 of the Provincial Small Causes Court Act, or under a usual civil court depending on the city in which the premises are situated. Now, what I have observed is that usually this dispute arises between the licensor and licensee mainly on account of execution of agreements for sale. So there is an increasing tendency where at some point of time the licensee feels that let me buy this house. So he executes an agreement for sale. He says that I'll go and take loan, give me 2 months time, 3 months time. And then once the full payment is not made, or if there is any delay in payment, the landlord then loses interest in completion of transaction. In usual cases, the the seller is the king. If the transaction doesn't fructify into sale, the purchaser has to go and file a suit for specific performance of the contract. In this case, the situation is reversed because the licensor is already in possession of the premises. So what he does is that then the landlord exercises a remedy under section 24 saying that the term of the license has expired and please pass an order of eviction. The usual tendency of licensees in such cases is that, but I am purchasing this, I have paid 80%, I have paid 30%, I have paid 50%, and I am in possession. And then he seeks to defend that particular eviction action. According to me, as I said, the limited remit of inquiry under 24 is only expiry of license. If the competent authority or the court finds that the entry of the licensee into the premises is by virtue of license, and once the license expires, section 24 remedy has to be granted. If tenant has any grievances outside the tenancy agreement, say based on an agreement for sale, he can adopt his own remedy for seeking specific performance of that contract. And he can also claim protection under section 53 capital A of Transfer of Property Act. So instead of wasting time before the competent authority trying to save the eviction order, it is actually advisable to file a remedy of civil suit and seek an injunction against eviction. Because the competent authority cannot really go into all these issues as to whether there is a valid transaction of sale or not. At the same time, the flat owners, this is what I increasingly feel, need to be very cautious while selling the premises to a licensor. So you should either complete the transaction